Alrighty, everyone. Welcome back to another episode of Law Schoolers. In this episode, we are talking about remedies, social impacts, and alternatives to Miranda warnings. We only have 3 episodes left, including this one. So it's been a long haul, and in a very short period of time, but we are almost done as far as this course goes. And then we anticipate creating more, and those episodes are going to come out next month, just based off of the limitations that the host and provider has of how many hours of media I can upload per month. So, let's talk about this case. Remedies, societal impacts, and alternatives to Miranda. What are the case-level remedies? What happens if there's a violation of Miranda rights? Well, what this case says, Missouri versus Seibert, whether the Miranda warnings are delivered midstream could have been affected enough to accomplish their object. In other words, if the conduct of the officers is calculated to undermine Miranda and the purpose of Miranda, well, then those statements are going to be out. Well, what is the purpose of Miranda warning? Well, that purpose is to inform the defendant of their rights and to put them in a position where they can use those rights if they want to. In this case, Missouri versus Seibert, the method of interrogation was deliberately designed to work around those Miranda rights by coaxing a statement pre-warning and then giving a proper statement post-warning, which they know is likely to be waived. So they know that the first statement is going to be out, but then they go ahead and give a warning, anticipating that it's going to be waived, and then get a post-waiver statement, thinking that that is going to be in. And what the court says is, no, that can't be in, because the whole purpose of Miranda is to inform them of the rights, and you're kind of coaxing this statement out of them before they're informed of their rights, knowing that later those rights are likely to be waived. So this case is kind of distinguishable from another called Oregon versus Elstad. In that case, an officer obtained a statement in the home of the subject and obtained that statement almost accidentally as the officer attempted to explain to the the mother of the accused, why that person was going to be taken into custody. Later, in the actual interrogation room, the accused did waive their Miranda warnings after being given a Miranda warning, and then they issued a confession. In that case, the first statement was excluded, but the second statement was admitted. In this case, Missouri versus Seibert is different from that because the purpose was in Seibert was intentionally to circumvent the purpose of Miranda, and there it was almost accidental. In this case, the questioning occurred in the police department only after a short break of about 20 minutes, and the questioning was closely related. Everything in Seibert was designed to work around the standard instead of the unintentional good faith mistake of the officer when the timing of the warning is supposed to be issued. In State versus Smith, we've got a couple of examples here. After the officers pulled over Jones, and Jones failed to produce registration, Jones was put in the back of the police vehicle while registration was being looked up. Smith was Jones's passenger, and the officers continued to question both Jones and Smith about the ownership of the vehicle and whether there were any illegal materials within that vehicle. Smith did confirm that there was illegal material in the vehicle. A search ensued based off that disclosure and discovered the illegal material. After the discovery of the material, Jones and Smith were read their Miranda rights at that point, transported to the station, were read the rights again, and there they made a full confession about stealing the vehicle and then the drugs being within the material. Now, the question is the second confession made at the police station, is that going to be excluded as evidence? And underneath a case called, in Tennessee, where this court case was done, this was going to be admissible because it was deemed to be separate statements. If we were to apply the federal rule that we talked about in the previous case, the first statement might not even be in custody in the first place, so there might not even be a Miranda violation there. But this case appears to be more like another case called Elstad instead of Seibert, and so the evidence could come in at trial. Then we have DeShields versus State. DeShields had invoked his Miranda rights, and after he had done so, he was pressured to talk and confess about a killing that occurred during a robbery that ended up going wrong. He admitted that items from the robbery had been discarded in a ditch, and the officers found the items in the ditch and linked DeShields to the murder of the robbery based off of those items. His testimony was not admissible because it was a violation of Miranda, but the items discovered were admissible due to inevitable discovery underneath the U.S. versus Patain. And underneath U.S. versus Patain, physical evidence is going to be admitted regardless of whether or not it is inevitable discovery. The default remedy for a Miranda violation is that the statement and the fruit of the poisonous tree is going to be inadmissible as evidence. There are exceptions, though. Our first is Elstad with those Seibert limits. Elstad was the one where the officers were acting in good faith, and the Seibert limitations were you can't work around Miranda. Our second limitation is impeachment of the defendant using the defendant's voluntary statements underneath the coercion test. So Miranda was wrong, but the statements were properly voluntarily made. You can use those to impeach the defendant when the defendant is on the stand. And third is physical evidence disclosed in a statement as long as the statement was voluntarily made. Let's talk about societal impacts of Miranda. What kind of effect did Miranda have on society? Well, we've got an article that we ended up reading. It was titled Police Interviewing and Interrogations, a Self-Report Study of Police Practices and Beliefs. This article discussed past empirical research on the effects of Miranda and compares the information to studies from self-reported officers. Pre-Miranda, this study discovered that more than 80% of individuals waived their Miranda rights, that police believe they are better at detecting lies than they actually are, that normal interrogations are shorter, while interrogations producing false confessions tend to be longer, and that individuals generally confess about 55 to 65% of the time. Now, post-Miranda, this article discovered that we have similar rates for waiver, which is about 80% of Miranda rights, and that police believe they are better at detecting lies than they actually are, so no change there. What does change a little bit is that innocent suspects provide incriminating statements about 25% of the time, and that individuals provide general incriminating statements about 68% of the time, just a little higher than the pre-Miranda time frame. Essentially, what it appears is that Miranda has a minimal impact on the effectiveness of obtaining confessions through interrogation, and all it really does is that it seems to give the police a structure to where they know that the evidence is going to be included or excluded in a very clear manner. What about potential alternatives to Miranda? Well, the main alternative that one might have is recording, the use of recording devices during an interrogation. We have here a memo from James M. Cole, the Deputy Attorney General of the United States, policy concerning electronic recording of statements. Essentially, if the subject is in the place of detention where there is a recording device and the subject hasn't gone to court yet, there is a presumption that the interview is going to be recorded. And if the subject doesn't want to make the recording statement, well, then that recording is not required. Why is this an alternative to Miranda? Well, it's just simply making sure that the defendant has their rights protected, that material isn't going to be voluntarily coerced, and that the defendant has the opportunity to say, hey, my rights were waived, my rights weren't waived, they were properly invoked, and then they ended up continuing to question despite that waiver. Anyways, that's our discussion about remedies, case-level remedies, societal impacts, and then the alternatives to Miranda. Have a good one, and bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro, and you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is, if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.